Okay, good morning, everyone. We'll get started. Any late joiners can catch up. And I'm going to do a brief introduction today on IP in practice, an introduction to intellectual property and the rights and uses that you can make of intellectual property as part of a business. I hope you can all see the screen, the presentation. If not, please indicate. You can either speak up, as there's a relatively small number of us at the moment, or alternatively leave me a text message in the chat function or one of the other interaction routes. So briefly, what I'm going to talk about today is what is intellectual property, IP, the different types of intellectual property rights, IPRs. So we're going to talk about patents, trademarks, copyright, database rights and designs. A little bit about trade secrets, then move something on to the uses of intellectual property and the management of intellectual property in a business. So we start with what is intellectual property. One definition is that it is the product of human creativity. And we generally break these down into certain types. We call them inventions, which can be new products or methods. And any invention is really one or other or a combination of these. There are names and labels and other identifiers, and these tend to be known as brands or logos or trademarks. We'll talk about those. There's the expression of ideas, whether it's in literature, graphic art, performance, music, that sort of thing, and design and appearance. And this is the shape or decoration of products. And these are the classic definitions that come through and line up with the intellectual property rights. Intellectual property rights are the legal rights created to enable intellectual property to be treated like other property rights in law. Because in the sense that many of the products we're talking about are abstract in their general concept, whether they're embodied in physical things, we need a set of laws to let us use them. And the intellectual property rights define the activities to which a specific right applies. In other words, they tell us what things you have to do to get a certain type of protection. They establish certain standards to qualify for protection, even if the product is itself falling within one of these general definitions. Has it done enough to justify legal protection? And ultimately, intellectual property rights are business tools. They do have some rights and application beyond business, but generally they are tools of commerce, and that's the principal reason that they're used. So there are different types of intellectual property right that we're going to talk about. There are some rights that require some degree of originality or creativity to establish the right, and these are the classic ones of patents, trademarks, copyright, and design rights. But there are some other rights called database rights and trade secrets, which do not require originality or creativity. And we'll talk about those in detail. Even though they don't require this creativity, they are treated in essentially the same way as other intellectual property rights. So, first of all, patents. Patents protect inventions. And inventions can be basically broken down into two main areas: new things, products, apparatus, compositions and systems, and new actions, methods of making, using or doing. And a patent can be one or other or a combination of these or collections of these together linked by some sort of concept, but everything is either a thing or an action. Patents give the owner the right to prevent anyone else from using the invention without permission. It's called an exclusive right. It's the right to exclude. It's the right to stop other people. And that's the patent right that's there. It's important to note that patents do not give the owner the right to perform the invention themselves. They're not a permissive right. The issue here is that you can have a patent for an improvement of something which is itself already patented. That doesn't invalidate the patent that already exists. It says if you do it in a certain way, that is itself new and inventive and can be protected. So getting a patent doesn't mean you're free to go ahead. What it does mean is that you have the possibility to keep others off that area. And so, in other words, have space in which to develop potentially. Patents last for up to 20 years from, say, the first filing, essentially when you start the process, the filing. So they're forward-looking and for a period of 20 years. After that, what is in the patent enters the public domain. Obviously, things that are made that embody the patent may not, but the contents of the patent and become the public domain, and the rights that it had cease after 20 years. Can be less than that. It depends on things like patent renewal fees, but 20 years is the maximum. So what do you need to get a patent is the first thing. Well, the basis of the patent is a written application to Patent Office. We talk about written now, a lot of it's done electronically, but logically it's the same thing, it's a document. And it includes a technical description of the invention, how it works, what it does, its various features. And then things called claims. These define the legal scope of the patent. They're a set of statements. I mean, there can be just one, but typically they are a set of statements. And they set out the minimum set of features necessary to have the invention. So they're a minimum set. In other words, you can add to them, but as long as you've got that minimum set of requirements, the minimum set of features, that's the legal scope of the claim. You have the names of the inventors are necessary and the names of the applicants if they're different, and how they got the rights from the inventors, and some official fees. And that's the basic material on which the patent right is granted. Sorry, just 1 second. Yeah. Welcome to the late joiners. We've made a start, but you'll be able to catch up fairly soon. So the application can be searched and examined at the Patent Office. In other words, they can conduct their own research and decide whether what has been presented meets the appropriate standards. And where patent offices do that, the applicant gets the right to amend and argue if they object in some way to any aspect of the invention. So there's this sort of examination procedure that goes through one or more iterations. Can be formal, can be substantive, can be, are you using clear words and set it out correctly, and it can be you're trying to patent something that exists, and all variants of that sort of thing. But the process is one of negotiation with the Patent Office based on this document that you find. So consider now what inventions can be patentable, because I've said inventions are things or methods, things or ways of doing things. But there are a set of standards that apply to what can be patented. And to be patentable, the general rules that we've got here, and these are the ones that are broadly applicable, are that it's got to be new. In other words, it can't have been disclosed anywhere before the filing date, called novelty. So you can't patent things that are known. That's the short answer to that one. They've got to be inventive. And that means that any difference between what the invention is and what is known can't be obvious or routine. It must in some way contribute in a non-obvious fashion. And ultimately, they have to be what's called industrially applicable. I said, or not otherwise excluded. So we've got two things here. We've got a set of industrial applicability. Is there an industry or some form of commerce to which this patentable invention applies? And also we've created certain exclusions, usually for policy reasons, but occasionally for substantive reasons to define what is not invention. So industrial applicability, generally, if you've made an invention that's got a commercial use, you've got the industrial applicability in some way or other. The exclusions are for things that really are considered not to be inventions. So mathematical methods, numbers in, numbers out, not considered to be inventions. Obviously, if that's then applied to a physical constraint, then the invention might lie in some mathematical aspect, but as long as it's tied down in the real world, you may have it. And this applies generally. Methods of doing business in the UK and most countries are not. In some countries they are. US, for example, will be a bit more lenient on this. Some will say, well, if it's on a computer, you might be able to. So there's a bit of, but generally just business concepts per se are not protectable. Aesthetic creations, you'll find again where aesthetic creations are protected. Surgical or therapeutic methods, depending on the country. And this is usually a policy decision. You don't want doctors worrying about patents when they're conducting medicine. On the other hand, you might want to allow that in some cases. It does vary. Most countries don't, some do. Computer programs, again, per se, just an existence of a computer program is not an invention. Its use in some way that is tied to one of these physical and technical processes or products can be potentially protected. Anything that's contrary to physical laws and just discoveries. The mere discovery of a phenomenon or a thing is not itself an invention. You bring it into the physical world, you make use of it, you give it a purpose, you potentially got something there. So the question of patentability is judged by examination of the claims, these statements of the minimum sets of features that you have to have for the invention. And so what the Patent Office will do is it will take your application, it will look at your claims, it will conduct a search on the claims, it will examine the claims. The description is used to help them, but the claims are what the legal right is defined on. So that's where the Patent Office focuses. And novelty and inventiveness are judged in relation to what we call the prior art. In other words, everything that's known at the date of filing. And patent offices find this by doing searches. They'll search other patent applications because a lot of information is found there, and in fact only there. Now it's, of course, much easier to do online searching of technical information anyway. And one of the things you do notice now is that a lot more information is coming back from internet searches as well as just the basic database searches there. So the Patent Office will generally do a search and then will give you the feedback as to what it thinks of your invention, whether it's going to be allowable, what deficiencies there are, that sort of thing. So moving on now, we'll talk about trademarks. Different to patents, a trademark is something that indicates the source of a product or a service to the consumer in the course of trade. Trade in a very general sense, some sort of interaction, commerce. So charity, good works, they can also be trademarks or service marks. But it's a source of origin marker and allows the person looking at it to know essentially where something came from. So these trademarks can exist as words, logos, signs, patterns, sounds, animations, colors, lots of different things can be identifiable as a source. There are many of them. We encounter them in daily business. I mean, you'll see in this presentation, for example, we've got our trademark Wynne-Jones, we've got our little own thinking logo, we've got a nice little graphic design IP logo at the bottom there. So all, typically a large number of things, and they're used in many different ways. A trademark owner can prevent, with the trademark right, can prevent anyone else using the same or a similar mark on the same type of goods or services in commerce. So we've got a series of tests here. So it's the same mark, yes, a similar mark. So usually is it different but not so different that a different impression is created. And it's the same type of goods or services. I mean, trading different goods and services can be wildly different. And so you can get no conflict at all between what are nominally identical marks. Now, of course, this can change over time. And one of the classic example I give the trademarks Apple. Apple for computers and Apple Music, the record label set up by the Beatles. When Apple Music was created in the 60s, there essentially were no computer. An Apple computer didn't exist. So the Apple trademark was fine. It was for recordings of music and publishing and all those sorts of things. Apple Computer comes along, it makes computers. Again, at the time Apple Computer started, there was no real overlap between computing and the music business. As we've seen over time now, the two things have come together. computing becomes more technology platform, becomes things like iTunes and the backup services to that, and allows release of music and distribution of music, which is exactly what a music publishing business does. So we've seen things come closer and closer together over time, so that the distinction is more difficult. So today you would have a problem trying to put the two things together. Independently, a music publishing business and a technology company are going to have quite a big overlap, but at the time it may not. So this is why you can have the same mark in different areas, and there's absolutely no problem, because the two sets of consumers have a different mindset. It may be the same person, but they recognize completely different businesses. Usually they're very different. Also recognize that not all uses of a mark are necessarily commercial. The use of a trademark for reportage, for reporting, is not commercial use of a trademark. Similarly, use in other areas, in terms of examples, it has to be the mark applied to the goods or services, which is the controlled right. You can't preempt the whole word or an image completely from use anywhere in the world. It's got to be tied to trade some way. Unlike patents, though, a trademark owner can use their goods on the goods or services for which it's registered, the mark. So it's permissive right. The registration of a trademark gives the owner the right to use it. Remember, patents don't give the owner the right to use it. They merely give the owner the right to stop other people. So the registration says it is sufficiently distinctive of your goods that you can go and use it because nobody else is. As I said, someone else may have the same mark registered in a different area of trade, and they're allowed to use it there. So just because you've got a mark registered in one place doesn't mean to say you can then do what's sometimes called brand extension. You can go into other areas and necessarily use it freely. What do you need to get register a trademark? Here we go, the common theme, written application to Trademark Office. You need a sample of the mark. You need a list of the goods or services, and there's a nice little official classification system that lets you group those. The name of the owner, the official fees. And again, the application may be examined at a Trademark Office, and there's the usual cycle of amend or argue to deal with that. Most offices don't examine, or only examine for formal issues. They don't look at comparative areas, but some do, and some are quite rigorous on their examination, so it varies around the world. And essentially you can renew indefinitely. So once the trademark is registered, provided it's used and you pay the fees, it stays on the registers as long as you want. The trademark number 1 in the UK is the Bass Brewing red triangle. It's the red triangle you see on the Bass beer mark, registered in the 1870s and 1880s, I think. And it's still valid today. It's renewed. They've renewed it. They still use it. It's a good mark, and it's been registered for so long it's almost unchallengeable now in terms of beer. Interestingly, a red triangle also appears on a mineral water brand called Apollinaris in Germany, but there's no overlap. Beer and water are different things. So register. What can you register as a trademark? The point of the trademark is got to be capable of distinguishing goods and services in commerce. So it can't be just descriptive of the goods. It can't just be laudatory. Can't be just a simple piece of puffery, promotional term, or a common term or symbol used in relation to the goods or services. And it also can't be deceptive. The trademark cannot say something which is completely the opposite of the thing it is. So there are some general rules about that. But with all of those, there's also the possibility that despite having these characteristics about it, a mark may become distinctive by extensive use. So just because you've not registered a mark, if you use it a lot, it can become well known, even though to some extent it will have some aspect of either description or praiseworthiness or that sort of thing. But that's the key characteristic. It's got to be capable of distinguishing. It can't be an excluded mark. So there are some protected symbols that you can't register, the Olympic symbol, Red Cross, those sorts of things. And it can't be obscene or defamatory or illegal. So we don't have many illegal words or terms in the UK, but some countries do. I mean, commonly, many countries, for example, the use of things like Nazi symbolism is considered illegal and can't be protected in any way. But there are some exclusions there, and it must be different. So it's got to be different from other marks sufficiently that you can distinguish between them. Offices may examine for this, or they may not. They may actually just say, we've seen something that looks similar, and we're going to tell the other mark owner, this more senior owner, that you're around, and that's it, and leave it up to the owners to sort this out. And ultimately, unregistered marks may also have rights. There's quite a strong culture of giving reputation and what's called goodwill protection, even though there's no registration, whether it is in common law countries like the UK, where we understand this concept that broadly you have rights that arise from use and reputation. Other countries have unfair competition rules as well. So you don't have to register a trademark necessarily to get rights from it, and the unregistered rights can be very valuable, particularly if it's a mark that's been used for a very long time. But generally, you get some marks that arise from the actual user. Some rights arise from the actual use. Let's move now to copyright. Copyright protects original forms of expression, about how you express concepts. So the classic things you'll see are written works, books or screenplays, scripts or performances. Those are all classic copyright. Computer code is an expression. In a sense, it's a set of written instructions, written in a particular way, but in the same way that any other instruction book is written. Computer code is the same thing, and the code in and of itself is protectable by copyright. There are artistic works, pictures, paintings, photographs, stage designs, sculpture, that sort of thing. So 2 or 3D articles. And there's things like musical works, dramatic performances, choreography, those sorts of areas. So these are all about expression. It's the expression that we're trying to protect, not the underlying idea. What the copyright does is it gives the owner the right to reproduce the work and make adaptations and sell copies. I mean, then again, in a sense, if you have copyright, you're allowed to perform it. The copyright, if it's there, it is the right to do what it is. It's not an exclusive right the same way as say a patent is. You can prevent other people doing the same things without permission. I mean, it still gives you that right to exclude. And it gives you the right to exclude not just the whole work, but what's called a substantial part. A very qualitative test, what a substantial part of a work is. In written works, it's often people look at the amount that's there. But in something like musical works, it can be a very, very simple theme. As few as 4 or 5 notes in a theme, especially if it's a recurrent theme in a musical work, that carries the whole piece. So you can have relatively small quantities becoming protectable, can't be reproduced. Copyright does not protect the underlying idea. You cannot get copyright for the concept, you only get copyright for the expression. The example is you can't get copyright for the idea of a set of stories about a boy wizard who lives under the stairs and has got a scar on his head. You can get copyright for the particular books that have been written or screenplays that have been written about this, so that they're not reproduced. So you don't get underlying idea protection with copyright. Similarly, any sort of computer code does not protect all ways of doing what that computer. It protects that particular way of doing it. So the concepts are not protected, the expressions are. What do you have to do to get copyright? Well, unlike the other 2 rights we've discussed, this is automatic on creation of the original work. You create the work, the copyright comes into being automatically. There's no requirement for registration, although some countries do have a registration system, usually necessary for enforcement in the courts. So you have to register, then enforce. The US is the main one for this. Most countries don't. The copyright normally belongs to the creator unless there's some other arrangement. So an employment contract or a specific commission are the two areas that typically move ownership, but it's the creator, it's the writer, it's the painter, it's the sculptor, it's the photographer, unless all this work has been commissioned in some way. The rights last for the lifetime of the creator and 70 years from their death, 70 years after the death of the creator. So a piece of work that's created fairly early in a creator's life can have protection well in excess of 100 years. Now, this is a more recent extension. I mean, previously it was 50 years. Before that, some countries had less and less of that. So not all works are at this at the moment, but works created today are looking at this rule, which is the 70 years after the death of the creator. There's no renewal requirement or registration requirement. You have to pay for it. It runs that long. Quickly talk about database rights. They're a variant of copyright. The issue, though, is they don't require any originality of data. They only require effort in creating the database. So the data can come from public sources. There are many databases that have been, new databases have been created from public data, or even from data created from other databases. They pull them together in a particular way. So it doesn't require originality, it just requires effort. But the rights of the owner are essentially the same as those of a copyright owner. So it's the right to use and reproduce the database, stop others doing so, that sort of thing. But so as far as database rights are concerned, the short answer is treat them like copyright. They are slightly different. You don't have to have originality. So let's turn now to designs, what we call designs in the IP world. So they're about the appearance of products. So it's 2D or 3D shapes of products, decoration, ornamentation, combinations of these. It's what the thing looks like, not how it works. So a new product might have a nice, interesting function, but all that design protection cares about is what it looks like, not the functional requirements or the constructional requirements that go into it. You can't use design protection as a sort of a cheap way around the patent idea. It's a different thing. They're what are known as industrial or handicraft products. In other words, this is either mass production or reproducible to a large extent. They can't be individual creations. Designs don't apply to one-off creations, bespoke creations that are different from each other. But they don't have to be industrial. They don't have to be mass production. They can be handmade, handicraft products, provided they're repeatable. A lot of laws that come around this, they often say, how many units can you create for it to cross that line? It might be 10, 20, 50, that sort of thing. But it's a number of reproductions. And in the sense of replica, it's got to be the same thing, and certainly intended to be the same thing. Or perhaps variations that are inconsequential. So, different sizes, but the same design. Again, repeat again, does not protect the underlying principles of operational construction. And rather like many of the other rights, it gives the right to prevent anyone else making or selling without permission. It's another exclusive right. But again, like trademarks, it's also a permissive right, because it has been considered to be essentially a unique and new thing. Nobody else should be able to have design protection for that same thing that can stop you. Quick look at what you have to do to get one. If you want to register a design against written application, set of drawings or pictures showing the design. Design can be the whole article or parts or fittings. It's got to be a discrete part for the article. So you can see on the slide here, we've got a design, we've got a pen. The nib itself could be decorative, could have some shape that's beyond its mere function. That could be protected separately from the whole pen itself. So you can have nibs and pens, or just the nib for the pen, or just the barrel for the pen and ignore the nib. And so you could have the same barrel design for a fountain pen, a ballpoint pen, a fiber tip pen, that sort of thing. So, for example, and that's quite common. You think of the Mont Blanc designs, they come in a number of different versions. They look slightly different at the operational end, but the bodies are the same, so it's parts. You have identification of the product, and there's a set of classifications that group them into generally common areas. This is purely for examination or design purposes. I mean, once you've got the registration, it applies to any product actually. So we're looking at, so as I've said there, you might say have a design for a pen, but if the same design is used for a pencil, it still applies. You'd probably call them writing implements to avoid the problems, but those are the sorts of things. Name of the owner again, official fees again. Again, there can be applications can be examined at registries, and they will try and do. Usually, it's whether the thing is entitled to be protected as a design, and whether the design is clearly shown in a way that's understandable. Some countries do comparative searching. Most don't. The UK and in European countries, they last up to 25 years from the first filing, renewed in periods of 5 years. The very least, these days, it's 15 years from first filing. There's a convention that's really pushing everyone into a minimum of 15-year protection, maximum minimum possibility of 15-year protection, but 25 years protection on this one. So what can you register as a design? It's the appearance of the whole or part of a product. So it's the lines, the contours, colors, shapes, textures and materials, ornamentation applied to it, those sorts of things. It's got to be new, so there can't be a previous identical design or design differing in immaterial details. So immaterial details are features of design that people sort of edit out when they're looking at it. They don't consider them to be part of the design, they're incidental. Now, interestingly, the identical design, in other words, identical industrial design applied to a reproduced article. One of the great examples is that somebody created a salt shaker in the shape of the Eiffel Tower. The Eiffel Tower exists, but it's not an industrial design product. It's a one-off building. And so, yes, you can get protection for things like that. In other words, you make a product in the shape of something that already exists in a unique sense. And again, once they got the registration for the Eiffel Tower as a salt shaker, you could cover it for, a vinegar bottle, an oil bottle, pepper shaker, anything like that. It covers all industrial applications of that as a new design. But most, in fact, are not actually that. They're new creations completely. So it's got to be new, and it's got to have individual character. In other words, the overall impression must differ from the overall impression by a previous design. So it's not just that there are immaterial details. For example, you can see screws or rivets on things as opposed to just a plain area where while they're visible, they really don't affect the design. But the other one, the overall impression, in other words, is it similar but different enough to be distinguishable? And that can be very subtle. The mobile phone issues these days, pretty much everything looks the same. And for that reason, people attach a lot of significant to relatively small features. But it's got to have an individual character. In other words, something that makes it identifiably different. You can't get protection for features that must fit or must match another product. In other words, the inter-engaging bits that are necessary there to fit with something else. Those aren't considered to be design. And you can't get features that are dictated entirely by their function. A classic example of this are the arrangement of pins on an electric plug. Electric plug has to have those arrangements because otherwise it won't work. You can't get it into the socket. So those cannot contribute to design. The back of a plug might be configured in some way to look interesting, but the three prongs on the front end, that's got a combination. It's a must match, must fit, and it's completely functional. So those features that we're thinking about there, the test is typically, is there design freedom? Can the designer play with those, or are they constrained? If you can't make any change to those, you probably don't have protectable design features. The other thing as well, designs can't be contrary to public policy, morality, protected emblems. So again, things like the Olympic symbol, heraldry, can't be registerable as some form of decorative design. Unregistered designs may also have rights, rather like trademarks, usually much shorter, much more limited. Most of the rights you do get are a very short period to stop copying. It's the classic test. It can go a little bit further, but it depends. But most, it's just a short-term copying protection. Trade secrets. Moving on now. Trade secrets actually aren't intellectual property rights in most countries. There's a number of reasons why, but they're not products of creativity, and a lot of conventions about intellectual property require certain approaches to how they're enforced. So many countries carve out trade secrets as not being intellectual property. They have their own protection, or they're folded into some existing protection scheme. But a trade secret is information that's not generally known to the public, has economic value to the holder because it's not publicly known, and the holder makes an effort to maintain its secrecy. And this is a three-part test. You find it it's derived from WTO regulations. And most countries have elements of these tests in their laws. The UK, for example, doesn't have a trade secret law. We go under confidentiality, and it covers off most of those areas. Other countries will specifically have laws that say these things, but these are if you don't have one of these, you've got a problem with trade secrets. It's something else. Trade secrets, the information can be technical. It could be process parameters, internal product designs, manufacturing processes, those sorts of things. Things that are internal, you don't expose to the public, because they can't be generally known to the public. It may be accessible to the public, but not generally known. A good example of that, for example, is manufacturing processes. You can quite often go to manufacturing plants, and classic ones. Think about go and watch chocolate being made at Cambridge, and you will see their process parameters and manufacturing processes. But what you won't have knowledge of is what they are in detail. So generally known. So you can see them there. You can, to some extent, experience them, but you don't know them. There can also be non-technical information, so financial information, customer lists, supplier lists, pricing information, market surveys, that sort of thing. And these are actually very, very valuable. Trade secrets in this area can be the real value add, but the technical ones work as well. But the key thing about secrecy, it's got to be secret. What do you have to do to get a trade secret? Well, first of all, you have to generate or collect the information. So the information can come from public or private sources. So a collection of public information put together in a new way can be a secret. So market surveys, for example, you go out and you talk to the members of the public and ask people questions. All of this information comes from the public domain, but is collected together in a way and constructed and given context in a way that isn't known. And so that becomes a trade secret. You've got to identify its value. That doesn't mean, say, give it a value, but you've got to give something that says it's what we recognize that this is worth something. This is, there might be some value in its collection, the cost of collection. But for example, a market survey for a new product has clear value because it's about part of a value process. And then you've got to keep it secret in some way. So you don't tell anyone outside your business. You make sure everyone in your business who knows it's a secret, that it is a secret and has to do it. You use agreements and contracts to protect confidentiality. You don't reproduce it in patents or any other documents because those then become public. They're published at some stage, and so you lose control of the information in them, even though you might be protected for the patent right. And recognize that if a product can be reverse engineered, you don't have control of that information once you've sold it. But trade secrets can last indefinitely, certainly very long periods. A lot of people will say, "Oh, what would we think of things? Oh, well, the Coca-Cola recipe, KFC's herbs and spices for their chicken." To be honest, those yes, they may be trade secret. They don't actually last indefinitely. The recipe for Coca-Cola changes regularly and a lot, so that in itself is a it's not one thing, and you can reproduce them. Is the information there when you can work out what it is, especially if it's taste. If you can reproduce that taste, it's fine. Some things, though, you really don't find out. I've worked with in a former job when I worked in a house, we used to make sensors, and the material we used to make the sensors was a unique alloy that had been optimized for the purpose. And you never told anyone what that was. And even if they bought one of the sensors, they wouldn't really be able to work out what the original alloy was because of the protective atmosphere and the degradation that happens as soon as you disassemble the thing. And it was at the level where that really made a difference. That, as far as I know, is still being, still as good as it was now, nearly 50 years ago. And it's an optimized, very sensitive detector. So it can last indefinitely. So let's turn now a few questions of the uses of IP. Now you've got your IP and your IP rights, what are you going to do with them? What are they there for? One of the first values is there to secure the value of the results of R&D and business development. I mean, as you can see, these intangible things, these are a set of rights that sort of tie them down and make them usable in a commercial context. And by doing this, you secure investment in R&D and business. And you contribute to the value of the business for sale because you create rights, you create things that the business owns in the same way as you would with a product or other bits of property, as opposed to leaving them unprotected. So intellectual property is about securing value and in the investment someone's made, whether it's intellectual investment in the sense of creativity or financial investment in terms of funding these sorts of things. Intellectual property rights also serve as a deterrent to competition. So we've given all these examples of how you can stop people doing things and stop them entering the market. So the risk that somebody infringes your rights can be a deterrent for them entering the market. So it sort of clears the way ahead of you. You keep an open path. And the point there is that gives you the opportunity to scale your business up into that area because nobody else will come in. There's a deterrent there. There's a big sign that says this is someone else's property. Yes, there's the risk of enforcement through the courts. I mean, that's sort of the nuclear option. You don't do that until the very end. But that's what ultimately defines the risk. And that reduced competition gives you space to scale up. So you secure the value, you also keep everybody away from the field that you're working in so that your business can grow if necessary or develop. And finally, there's a licensing possibility. Because you can stop people doing things, you can grant people the right to do it in return for a license royalty. And so you might take the funding from that. So particularly if you've got some form of intellectual property that's useful either in a non-competitive way, you've got a business but it's also useful elsewhere, so you can get extra revenue streams because you can get that, or alternatively because you are not in a position to commercialize your intellectual property fully into the market you're interested in, and so you just take a little piece of everybody else's market as well. So those are three typical uses, and they're not necessarily the priority, but certainly the securing the value is one of the fundamental reasons why you do this. Management of IP, we'll start to wrap things up now. There are some general approaches that you can take in a business for managing IP. First one is responsibility. You make someone in the management of the business responsible for intellectual property in the same way that you tend to make them responsible for other things like people and facilities and health and safety. It has to have a name on it because these rights, generally, if there's no one responsible, they don't get done. You need a strategy. You need to identify where intellectual property can add value to your business. So you develop the IP strategy that finds those areas and therefore has to align with your business strategy. There's no point in getting IP protection for things that don't align with your business unless you really do have an opportunity to generate value out of those. There's cost and effort involved in it, so it's got to be also aligned with your business. Generally needs a budget. IP activities have costs attached to them. Even those things that appear to be automatic, things like copyright and trade secrets, need management. They need effort to control them in some way. So you need a budget that's for dealing with your IP as a business. It's got to be consistent with the resources available. I mean, you can't have a budget that goes beyond what you can spend, and also what your objectives are. I mean, you need the appropriate budget to do what you need to do, both in terms of business and in terms of the IP. as with all budgets, stick to it. It's there for a reason. But budget management in IP can be an issue because IP costs can be very high. And one of the classic ways of managing budget is to drop old things, to free up resources for new things. Hanging on to old IP that is non-productive is one of the classic problems that businesses have. And clearing out the dead wood and giving yourself some opportunity to use those resources for new things is often a good way of doing that. And finally, there's advisors. Use advisors early and often. Unless you have a real knowledge of IP, this is a specialist area in the same way as use accountants or any other advisors. They can help you a lot. You need to let them know your budget, what you can and can't afford, and let them help you get to the end of it. Saving it until you're very much up against the limits and you've got, right, it's the last minute thing to do is classic expensive way of doing things. Gives the advisors less room to advise and maneuver. So, conclusion. IP can contribute to the value of your business. It can contribute a lot to your value of your business. And many businesses are essentially IP. Proper selection of the IPRs is important. Again, it's one of those things that you need to know what your business is. The costs can be high, so you need to manage actively. And using advisors is a very, yes, of course, I'll say that I'm an advisor. Unless you have a good understanding of how this works, you're going to need someone to help you with this. The more you can actively involve them, even at a very early stage and with a bit of direction, the more likely you are to be successful. So with that, I'll say thank you. I hope that's been useful.